My name is Roan, and I'm the State Training Director for the Colorado State Public Defender. I've been with the State Public Defender's Office since 1990. When I was in law school, I clerked for a private firm, and after graduation, I began to work for them, and so I did civil law for a while. I moved to the Public Defender's Office because I wanted to help poor people and I wanted to get experience in the courtroom. I left the Public Defender briefly when I had my first child, and I was fortunate enough to do a year of First Amendment law during that time. New graduates are going to succeed in the practice of law if they have the kinds of skill sets that would include understanding how evidence works on the ground, being able to structure a cross-examination, understanding how to pick a jury, and understanding how procedure works in terms of, what is a motion for summary judgment, and how do you write one, and what do you expect to do with that, and why is that an important move in your case. When students finish law school and they've taken evidence, they don't seem to understand that in the real world, evidence is either a sword or a shield, and it's an incredibly tactical set of rules, and it's that tactical application that we have to spend a lot of time sort of starting from zero with them. One aspect of legal education that I think is interesting is the lack of emphasis on procedure. If you're teaching somebody how to play soccer, you don't just teach them how to kick and how to punt. You teach them what the rules are, what offsides means, what a corner kick is, what penalty kicks are, because you have to know the rules of the game before you can excel in acquiring the skills of the game. And I think law is exactly like that. I think that these practical skills can be started in law school if there is a re-examination of how much focus is put on doctrine and how much focus is put on practice. Both are incredibly important, but the majority of people that graduate from law school want to be lawyers and want to practice in a courtroom, and I think that as educators, we fall short of what they deserve when we don't give them that very practical education before they go looking for their first job. One of the problems with having all learning happen in court is that it's really scary, because in court bad things can happen, sometimes even to the best lawyers in the world. And so we take a very we make a very concerted effort and sink resources into taking people out of the courtroom and putting them into the classroom so that they can experiment with skills. We sometimes say, in the course of this training, no clients will go to jail. And it calms people down, and it helps them figure out things when the stakes are low so that they know they can do it when the stakes are high. And that replicability of action is a huge part of teaching somebody how to be a trial lawyer, because you have to develop the same kind of muscle memory for picking a jury that you would for doing a physical task. The protocol right now for training our new lawyers starts with a two-day program called Core Trial Skills that they have to complete within 6 months of hire. And that 2 days is broken up into some lectures in the morning, but then just practice all afternoon. And so we practice picking a jury on the first day, we practice cross-examining witnesses on the second day. Once they finish that, before they can go into district court to represent people who are charged with more serious crimes, they have to go through a 6-day boot camp. And for that program, everyone brings a case that they're working on. And we workshop that case for 6 days. We brainstorm it. Again, we bring in people so that they can practice jury selection. People play witnesses. They give closing arguments. And then what's really terrific is that they go out and actually try those cases and report back on their success rate. And people win their boot camp cases 90% of the time, even really hard cases. And that way of training, I think, in addition to mentoring in the office and pre-trying a case before it's set for trial, but that removal from the office milieu and the intense concentration on one case and one lawyer makes all the difference in the long run with respect to how good our lawyers are. Some people wonder if boot camp is something that we can sustain as our system continues to grow. And I've made the choice that it will always be a bring your own case situation, very small class sizes, lots of faculty involvement, and it will always last 6 days. Because if you're not constantly checking in to see where your students are, then all you're doing is talking. And talking doesn't really do a whole lot of good for anybody in terms of them figuring out how to take what you're showing them and integrating it into their practices. We do terribly important jobs. All lawyers do. Law's a big deal in our society. And if we take the position as teachers and trainers that it's too labor intensive to figure out a way to structure learning experiences so that we can be sure at the end of it that everyone has moved down the same road together with a common understanding, then I think that we're not upholding our end of the bargain. The reason that this project is so valuable right now and so central to the place that our country's at is because educating lawyers has never been more critical than it is now. I say that because the public is losing confidence in the courts. And when the public doesn't have confidence in the bodies that are selected to decide our disputes in a way that is fair and in a way that is principled and in a way that ordinary people can understand, then that's a really serious threat to the foundation of our country. I think we take it for granted that we live in a pretty orderly place, that things aren't resolved in a chaotic fashion or a violent fashion, but that only continues to happen if people continue to believe that our courts are working in a way that's not only effective or getting cases done, but are working in a way that is principled and that upholds our Constitution and its provisions and promises that are made to everybody, regardless of where you were born or how much money you have, or, you know, as Gideon said in his petition, what color I am or what church I belong to, if any. None of that should matter, and none of it can matter if our country's going to keep going forward. But the way that people have confidence in our courts is that all of us, the lawyers, the actors in those courts, behave in a way that is informed, that's professional, that's at the highest skill level possible, and that brings some understanding of the giant historical burden that we have to carry forward for our children and for people who are going to go into those courts later on.